Hello, my name is Dan Wall, and I'm speaking to you from Ilisagvik College here in Utqiagvik, Alaska. And today what I want to talk about is federal Indian law. It's ironic, perversely ironic, that when we talk about Indian law, we are usually talking about laws made not by Native Americans, but by the federal government and imposed upon Native Americans. But for the moment, the purpose of this discussion, or this video anyway, is to outline three separate cases which together form what's known as the Marshall Trilogy. And they're called the Marshall Trilogy because all of these cases go to the U.S. Supreme Court when John Marshall is Chief Justice. So we need to know a little bit about who John Marshall is. And the most important thing to know about who John Marshall is, aside from the fact that he is Chief Justice from 1801 to 1835, and probably the most influential judge to ever occupy the Supreme Court, or really any judgeship in the United States. The other thing that's most important to know about him is that he is a Federalist. And what that meant back in the day is that when questions about where the balance of power should fall between federal and state governments, John Marshall consistently tried to allocate power to the federal side of things. As much as possible, he wanted to expand the power of the federal government at the expense of the states. Some might say he did it within reason. Some might say he went a little too far. We don't really need to decide that kind of battle today. But the important thing to understand is that when the question of tribal rights or the powers of indigenous people comes up, it gets sort of caught up in that debate between federal and state power. And to a large degree, the beginning patterns of what will become federal Indian law are established by Marshall's agenda. Okay, so now the Supreme Court, they're not supposed to write law. They're supposed to interpret law. And for the most part, ever since Marbury versus Madison, they have spent a fair amount of time interpreting the U.S. Constitution and deciding whether or not various laws are consistent with that Constitution. So one question you could ask before we go into the actual Marshall Trilogy is, what does the Constitution have to say about American Indians and Indian tribes? And there are two real references in the U.S. Constitution to indigenous peoples. Whether or not they're helpful is an interesting question, but they're both worth looking at. The first is in the infamous 3/5 clause, which, of course, hopefully you remember this from your high school history class. The 3/5 clause is about counting the number of people in a state. And it essentially, it ends by saying that for purposes of representation in Congress and so forth, in the House of Representatives, that slaves will count as 3/5 of a person. Well, that part I think most people remember. What most people forget is what comes just before that, which is excluding Indians not taxed. So essentially, the 3/5 clause includes a provision that says if Native Americans, or in the language of the day, Indians, are not paying taxes, if they're out there sort of in their own community and not part of, for lack of a better phrase, mainstream American community, then you don't count them for purposes of the census, or at least not for purposes of representation in the House. And that's really all that clause says. The second major reference to indigenous people in the U.S. Constitution is the Commerce Clause, which is the third clause in the enumerated powers of Congress. And it essentially says that Congress has the authority to regulate trade between states and with foreign nations and with Indian tribes. And that's really it. That's what you find in the Constitution. So it's tough to avoid the conclusion that maybe when America's founding fathers were debating, what the new Constitution would look like, at the Constitutional Convention that they didn't put a lot of time into answering the question, what is an Indian tribe, or how they want to deal with indigenous rights. That doesn't seem to be high on their list of priorities. But it's important to understand that's really what is in the Constitution. So when the Marshall Court gets these cases, these 3 cases that I'm about to talk about, that's all they've got to draw on. That and anything outside the Constitution that they can try to use as a guideline. But that's it. That's what they have to go on. So the first of the 3 cases that we need to talk about is known as Johnson versus McIntosh. And this case is decided by the U.S. Supreme Court in 1823. And one way of thinking about this case is that, in a sense, it's the U.S. Supreme Court deciding how the doctrine of discovery will work as applied to indigenous people in the United States. And what do I mean by the doctrine of discovery? Well, one way of thinking about it, if you've ever seen, probably in cheesy movies or television shows or something, a European colonist lands in some new lands. Yes, they land in new lands. And plant a flag and say, I stake this claim for Spain or England or France or whatever. What are they doing? And whatever else they're doing, they're saying to other European powers, leave this alone, it's ours. But for purposes of indigenous rights, the question is, what does it mean in terms of relations between that kind of colonial power and the indigenous people of the area? And roughly speaking, you could think of the doctrine of discovery as an authority claimed by colonial powers to extinguish indigenous rights. And whatever else we're dealing with when we're looking at Johnson versus McIntosh, we're looking at the Supreme Court trying to decide how that's actually going to work. And notice I'm sort of finessing some of the political questions about whether or not this, colonial power should have this kind of authority. What we want to talk about here is sort of how the court is going to use that idea, for better or for worse. So at any rate, one thing also worth bearing in mind is that if the doctrine of discovery is a claim by a colonial power on the right to extinguish indigenous title, it's important to understand that doesn't necessarily mean indigenous people lose all their land the minute a European sets foot in the territory. There's a process, and what that process can be varies from one colonial power to another. So you might have, for example, the Spanish out there reading a document known as the Requirimiento, and when they first encounter a village, there are lots of other things. It's the U.S. Supreme Court that's going to decide how that works in the United States. And they begin to do that with Johnson versus McIntosh. Johnson versus McIntosh is a case between 2 groups of non-natives claiming title to the same land within actually the state of Illinois, but it was land that had formerly belonged to an Indian tribe. And on the one hand, you have Johnson and a few other people associated with his case that got the land directly from the tribe themselves. And they got it prior to the American Revolution. On the other hand, you have McIntosh and a few other people on his side of the case who got a patent from the United States. So you have, on the one hand, people who got the land directly from the tribe, and on the other hand, you have people who got the land from the federal government after the Revolution. And notice, none of these parties are native, but they're claiming title to native land. And the question is, which title is valid? Now, if you remember, as I said a minute or two ago, that John Marshall is a Federalist, maybe you can tell where this is going. What the court is going to rule in this case is that it is the federal government that controls indigenous land, and that it is up to the federal government to decide when and how indigenous land is transferred away from a tribe to anybody else. So the court in this case is going to rule on behalf of McIntosh. Essentially what had happened was Johnson and Company wanted to evict McIntosh, and the court is going to say, no, you can't do that, because McIntosh's title is the one that's valid. he got it from the federal government. And the final sort of principle that comes out of all of this is the notion that it is up to the federal government to extinguish indigenous title. Only the federal government can extinguish indigenous title. Now, another way of putting that, you could say only the federal government is going to steal Indian land, only the federal government has the right to steal Indian land. If you want to put it that way, I don't think I'd argue. So anyway, that's Johnson versus McIntosh. And by the way, it's worth bearing in mind, the idea that only the federal government can extinguish indigenous title has a lot of interesting economic consequences, among other things that makes it harder to start a business in an indigenous country, because one of the ways that you start a business is you get a loan. In order to get a loan, you usually want collateral, and that usually means being able to show a bank or some other source of a loan what it is they can take if you fail to pay it back. And of course, if you have a legal principle like, say, Johnson versus McIntosh that says your land cannot be transferred to a non-native party, then that makes it a lot harder to get a loan. And of course, there are all sorts of other grants and policies that deal with that now. But one way of thinking about that is it's one of the limitations that people trying to conduct business in indigenous countries have to deal with. And they do it in a variety of ways. But anyway, so that's Johnson versus McIntosh. Okay, so the second of these three cases is Cherokee Nation versus Georgia. And this is a case that is decided in 1831. And it involves efforts by the state of Georgia to pressure Cherokee into moving west of the Mississippi River. They want to move them into Indian Territory, mostly present-day Oklahoma. And this is part of a general move that was taking place in the 1830s. It had actually begun much earlier, and sort of the efforts to move tribes from the southeast west was sort of on again, off again in the early years of the Republic. But in the 1830s, you have the passage of a law known as the Indian Removal Act. And of course, you have Andrew Jackson as president. He certainly wants to move tribes west as much as possible. And so there's a renewed effort to force Indian tribes out of the southeast. And Cherokee Nation in particular, well, the tribes in the southeast, the major tribes to pay attention to here are often known as the 5 Civilized Tribes, which is a really interesting phrase in itself because it sort of illustrates a degree of non-native bias in the phrasing. But these tribes, the Cherokee, Choctaw, Chickasaw, Seminole, and Creek nations, all 5 of them seem to be adopting certain aspects of non-native culture. And so a lot of non-natives would look at them and say, oh, look, they're civilizing. Now, whether that's an accurate description of what's going on or not is an interesting question, but the key here is to understand that groups like Cherokee are beginning to adopt a number of institutions which non-natives might have found recognizable. Part of this is there's a lot of intermarriage going on, so actually you have mixing of populations, which is one of the reasons why you might find a lot of Irish or Scottish names in some of the old tribal roles or in some of these conflicts. But some of those features of non-native culture that groups like Cherokee seem to be adopting would include a certain degree of Christianization, writing systems, and in particular the Cherokee had developed their own syllabary and improved, established literacy throughout the tribe. Large numbers of Cherokee knew how to read and write in the syllabary. They had their own newspaper in that syllabary, and so you have writing systems, right? You also have participation in local commerce, plantation agriculture, which, by the way, means there was also a degree of slavery, and I'm going to resist the temptation to launch down that discussion because it's an interesting topic in itself. But these are the sorts of things that had a lot of non-natives looking at groups like Cherokee and saying, see there, these are the civilized tribes. Now, part of what's interesting about this is you would think, given the amount of time that non-native leaders have spent saying, we want to guide natives and become like us and civilize them and bring them Christianity and reading and writing and a whole range of other things, you would think that evidence that tribes were doing this might be viewed as positive. But that doesn't seem to be the case. In fact, in many ways, what it seems to do is institute a kind of panic among people who are thinking, this is kind of a sarcastic way to put it, but it's almost like, if they become too much like us, we won't be able to steal their land. And so there is a strong effort to push them out more quickly. And so what you see is the more Cherokee begin to do various things that make their society look credible in non-native eyes, the more outsiders push to move them out quickly. And so one of the things that particularly gets the interest of outsiders is the Cherokee will adopt a constitution in 1827. And they submit it to Congress for recognition. And it's a constitution very much like any other modern Republican government would have. And in direct response to this, the state of Georgia passes a law that essentially declares the Constitution null and void and extends its jurisdiction into Cherokee territory, and establishes a number of particular features, one of them being that any non-native that wants to go live with Cherokee has to get a license from the state of Georgia to do so. So that would give Georgia the ability to control missionaries and trading posts and so forth that are set up in Cherokee territory. Not to mention, let me just emphasize again the idea that Georgia law would apply to Cherokee territory. So, you can see that pattern. In other words, as Cherokee do something which ought to add to their credibility from the standpoint of American law, what they get is pushback, along with, a variety of efforts to kind of harass them and push them out. And so this creates a number of interesting divisions within the Cherokee Nation itself, because the question is, what do you do about this? And there were voices that talked about potentially just literally fighting over this. There were some who said, let's just go. Let's just get away from these crazy people and go to Indian territory and make things work there. And then there were others who said, no, we can fight this. This is illegal. We can fight this in the U.S. court system and we'll win. And that included, that faction included people like John Ross, the chief of the Cherokee Nation at that time. And so they do exactly that. They file a lawsuit. They take it directly to the U.S. Supreme Court. And they challenge the legality of those Georgia laws. What happens next? Again, this is 1831. John Marshall is still Chief Justice of the U.S. Supreme Court. And he gets this case. It's a lawsuit from a tribal government against a state, the state of Georgia. And the official, how would I put it, the official case for jurisdiction, in other words, the official basis for jurisdiction in this case, is a provision within Article 3 of the U.S. Constitution that outlines the jurisdiction of the federal courts, which allows those courts to hear conflicts between a state and a foreign nation. And the Cherokee Nation says, we're a foreign nation. We're obviously a foreign nation. That's why we brought the suit. The state of Georgia says no. They're not a foreign nation. The boundaries of Georgia have already been spelled out. They're within our boundaries. Whatever they are, they cannot possibly be a foreign nation. Now, one of the things that's kind of interesting to think about here is what this case might have meant to John Marshall as a Federalist. Because on the one hand, if he sides with Georgia, he's giving a lot of power that the federal government would normally exercise. He's giving it to the states. And that's not something he's really going to want to do. But the second thing is, if he sides with the Cherokee Nation, well, Andrew Jackson wants all these tribes moved west anyway. If the Supreme Court makes a decision, it really is, people under the executive branch of the U.S. government that are responsible for enforcing it. So what are the odds that decision are going to be enforced anyway? So if you're John Marshall, you really kind of don't want to rule on the merits of this case. And for those who are familiar with Marbury versus Madison, he has some tricks, we'll just put it that way. So in this case, what Marshall does is he looks at jurisdiction. And he looks at the question of whether or not the Cherokee Nation are a foreign nation for purposes of the U.S. Constitution. And the way he answers that is he goes and he points at the Commerce Clause. In other words, that third clause in the enumerated powers of Congress that says Congress shall have the power to regulate trade between the states and foreign nations and Indian tribes. And Marshall is going to say, well, why are Indian tribes mentioned alongside foreign nations if Indian tribes are foreign nations? And so Marshall is going to say, obviously they must mean something else. Now you could argue with that. It's kind of too late. The decision is long since made. But I mean, arguably that kind of happens in human communication. And there were certainly other parties at the time who said, no, the Cherokee Nation is a foreign nation for purposes of this kind of lawsuit. This doesn't make sense. But anyway, what the court is going to rule is that Cherokee Nation are not a foreign nation, which leaves open the question of what are they? And this is really what's going to become the most important outcome in this particular case. Because Marshall is going to rule that Indian tribes are domestic dependent nations. So what is a domestic dependent nation? Well, to this day, there are lawyers all over the United States battling that out. Whenever there's a conflict between a given Indian tribe and outsiders, you can bet the lawyers on each side are haggling out implications that sort of address that question. But roughly speaking, probably the best way to explain it was articulated by a New Deal era lawyer by the name of Felix Cohen, who said roughly that a domestic dependent nation is a nation that retains internal powers of self-government. They can still, pass their own laws and so forth and govern matters involving their own people. But they have lost external powers of self-government. So they can't conduct their own foreign policy, they can't choose to go to war with a foreign nation, they couldn't negotiate a treaty with a foreign nation, for example. So the idea here is, another way of phrasing it might be the idea that tribes are sort of semi-sovereign. They've still got some sovereign powers, but not all of them. And the political implications of this phrase, like I said, they're huge. People are always debating them these days. People have been debating them ever since. But that phrase does seem to have defined what Indian tribes are for purposes of federal Indian law ever since. Now, in terms of the case itself, what does this mean? It means the Supreme Court has no jurisdiction. They've essentially accepted Georgia's argument against hearing the case or ruling on the merits of the case. And without necessarily saying that Cherokee are wrong about Georgia's jurisdiction, the court is saying, we can't help you. You couldn't bring this suit to us in this way. And so, again, without necessarily, saying, to the Cherokee Nation, you lose, the court is, by refusing to help them, sort of leaving them out in the cold. As a practical matter, they do end up losing this case by practical implications. As I struggle to make a very simple point. Anyway, so that's Cherokee Nation versus Georgia. And it sets the stage for the third of the three cases, and that is Wurster versus Georgia. Wurster versus Georgia. And Wurster in this case is spelled a little bit odd, but I do believe that's the way it's pronounced. Anyway, Wurster versus Georgia. This is a case involving an individual by the name of Samuel Wurster, who is one of 11 missionaries who, in defiance of Georgia law, went and lived and worked with the Cherokee Nation. And there's a reason they didn't follow Georgia law in this case. They had been actively working with the Cherokee all along. They had been fighting against Georgia's efforts to move Cherokee west. And it was pretty clear that if they went to the state of Georgia and said, hey, we'd like a license, the answer was going to be no. And of course, these missionaries didn't agree that Georgia had the authority to be doing this in the first place. So they just went in there. They just went in and started doing work with Cherokee Nation. They had been for quite some time anyway. Wurster had, so have some of the others. Georgia finds them, arrests them, charges them with a crime. They are found guilty and sentenced to hard labor. 9 of the 11 accepted pardons, and 2, Wurster and one other individual, did not. And the reason they did not was so that this could go to the Supreme Court. It goes back to the U.S. Supreme Court, and one of the other provisions within the Supreme Courts, or I should say within the jurisdiction of the federal courts, is the possibility of hearing a case between a state and a citizen of another state. And both Wurster and that other individual, they're not Georgians. So now it's in front of the Supreme Court, and now they clearly have jurisdiction to hear the case. So what is Marshall going to do? Marshall ends up ruling, in this case, on behalf of Wurster. And the basic legal principle in this case is the idea that states have no jurisdiction over Indian territory, at least not without Congress doing something to create that jurisdiction. So what does this mean? It means the state of Georgia had no jurisdiction to arrest Wurster. It means Wurster goes free. It means he can go work with Cherokee without a license from the state of Georgia. It also means, in practice, that the Cherokee Nation won, because Wurster is raising the exact same question that the Cherokee Nation had raised in the first place, the question of whether or not Georgia had jurisdiction in Cherokee territory. So with Wurster versus Georgia, you get a victory for the Cherokee Nation, but it's a legal victory. The political victory doesn't happen because, of course, again, Andrew Jackson is president of the United States. Andrew Jackson wants the tribes moved to the west. There's a quote that's often attributed to Jackson. It's unlikely that he ever said it or anything like it. And that is, John Marshall made his ruling, let him enforce it. There's no reason to believe Jackson actually said that. The reason that quote keeps getting cited, though, is that few things could have better described what happened. Jackson does nothing. He doesn't enforce the ruling. He makes no effort to do so. Harassment of Cherokee and others in the 5 civilized tribes continues, and eventually they are, pushed west in various ways. And what you eventually get is, with Cherokee Nation, a treaty is signed, known as the Treaty of New Echota, which is an interesting study in itself, but one we're not going to do at the moment. And it authorizes basically removal of Cherokee Nation, and this is what leads to the Trail of Tears, which is another story that we need to talk about in itself. But one of the things that is often left out of stories about the Trail of Tears, actually, is the fact that the Cherokee Nation had actually won this one case. And the reason I bring it up is because if you just kind of keep emphasizing the negatives, it's easy to miss that there are some native victories here. And if Wurster versus Georgia didn't help at the time, and arguably it didn't, it has certainly provided an important basis for indigenous rights today. So think of it this way. If the principle is that states have no jurisdiction over tribal lands, well, this is one of the reasons why casinos are possible. This is it's the key to a whole bunch of other issues as well. But that creates the basis for a number of policies that are predicated on tribal sovereignty, however limited or restricted it may be in the wake of the Marshall Trilogy and many, many other cases to follow. It does exist to that degree. So these 3 cases create the basic parameters of federal Indian law, and everything that comes since then is essentially sort of negotiating the implications of those 3 decisions. Some decisions will elaborate on them in various ways, some will deviate, but depending on the particulars of any particular case, you can usually see them working to one degree or another from this baseline that the Marshall Court set up. And that's it. Thank you. Okay, interesting detail, which I skipped, and I skipped it deliberately. But in Johnson versus McIntosh, remember I said that Johnson and McIntosh claimed title to the same land that had formerly belonged to an Indian tribe? Well, I lied. I'm sorry. They didn't. And the reason I lied is because I'm trying to tell you the story as it went down at the time. And that story is wrong, and it's wrong because they lied. As it happens, Johnson and McIntosh really didn't have title to the same land. Their lands were different. And there's evidence that they conspired to get the case before the court so that the court would have to make a decision so they could figure out really how non-natives could sort of approach the issue of acquiring title to indigenous land. Which is interesting in itself because, I mean, that sort of illustrates the degree to which non-native efforts to get into Indian territory are driving this whole process. But that's a little footnote which I don't like to explain when I first hit that case because it can be a little extra complication. But this, in other words, that was kind of a legal fiction that both parties agreed to so as to get it in front of the Supreme Court and get the court to rule on that, the merits of that case. And I'm done. Thank you.